So, first of all, hi, Jonathan. This is Rochelle Roberts, and this is our fourth Creative Jam. And today it's with Jonathan Tobin, and he is how would I say that you're calling your company semi-aware
Yeah, I have a company called Semi-Aware, and I have a law practice.
law practice.
Yeah.
And so I actually have known Jonathan. I know I've known your name for many, many years, and have seen your name forever that I can remember. And you're so I'd love to hear a little bit about your background and where you came from as a designer and a little bit of your story.
Sure. Well, I actually started designing back in the early 90s, during the first sort of CD-ROM boom. That
Mm.
was in 1993, before the internet was a thing, and I worked from there. So I started with design and software development, working to design CD-ROMs. And of course, as the web came in, I designed websites, and I did a good deal of print design that went along with that. And so around 2009, I had an idea to try something new.
Mm.
And at that point, I went to law school, and I went through law school, and I've become an attorney since then. Um, Simply
Okay,
because
hello,
yeah,
wait,
yes,
like
hi. Okay,
hello, like
yes,
that's amazing.
yeah,
Like I just have to
yeah,
stop. That's pretty amazing. And I want to hear what you were going to say after that, but
sure.
I just that's that's pretty amazing.
Yeah, it was quite a change. It was, it's a very different sort of set of skills, but at the same time, it's similar. And I think I was drawn to it because I was working for a lot of startups, and I had a number of sort of legal issues in my freelance career prior to that. And so
Mm.
both of those things together, they made me curious about how law actually worked, because a lot of what I was hearing or being involved with was more hearsay or speculation, and I had really a hard time understanding that. And I just wanted to try something completely new, because I had been designing for so long, and I still do design, but I wanted to expand uh, my perspective on design and on things like intellectual property and how you actually build a business from being creative. That's the thing that
Mm.
motivated me, and that's the thing that still motivates me today.
Mm. So let's go into that a little bit.
Okay.
Let's tell people. I want listeners to really understand what semi-aware is. What
Mhm.
is it? What? Yeah.
Okay, so it's sort of, well, I guess the best way to describe it is the way that I describe it um, officially, which is it's a um, it's a tool to help creative professionals and businesses use the law to make more money, do better work, and keep clients happy.
Hmm.
And so one of the underlying principles is that using the law and being aware of the law, or even semi-aware of the law,
Mm.
can help you to do those work with your clients, to make your work better, and to make money, which might seem counterintuitive to some, but that's sort of the thing I'm trying to change, to make people not feel afraid of the law and feel like it's something that you can approach and you can actually integrate into your business, whether or not you do some things yourself, whether or not you work with an attorney, or do some combination of the two. Um,
And I love. Okay, I just understood the semi-aware.
yeah, and I haven't explained it online, and I think I will at some point, but it's funny because I've sort of gone back and forth as to whether or not people would want to be fully aware or not. But the thing is it's sort of a pun, when not a pun, but
I
it's
I like the play.
I think to be fully aware, it's difficult, and maybe nobody really wants to spend the time doing that. But I feel like a little bit of knowledge, just getting sort of halfway there,
Mm.
will actually be helpful to a
Hmm.
lot of people who um, would either participate in our workshops, or the other thing that we'll be doing soon is producing books that can help you solve basic legal problems that anyone working in a creative industry might encounter, like how do you get a client to pay you who won't pay you,
Oh,
things like that. I mean, like the really nuts and bolts things that, as a designer, I dealt with, and everything I'm doing comes from experience, bad experience. I did everything wrong, and looking back, I see I could have done much better for myself
Mm,
had I mastered a few simple things, not even necessarily mastered them, but just been aware, just been informed about them and had a place to go where I could have my questions answered and understand what it is I'm involved with as a creative.
sure. Well, I'm so inspired by the way the perspective that you have as a designer, as a creative, and understanding so many of the challenges that you faced, and then being able to understand the law and to help creatives. I just feel like you have such an amazing perspective that um, it's really exciting to me. It really is.
And it has been interesting. It's been interesting for me to work with people and have the chance, one on one for my legal practice primarily, to work with people and see, things go from idea and begin to work themselves into becoming a business, or have people just feel like, okay, I have the legal issues locked down. I have a peace of mind. I
Mm,
know that, um, you know, one of the things I always say is, when you're working with somebody, as a creative, when you're collaborating with someone, it's always good to sort of get your assumptions out and basically discuss issues. And I find that by going through a sort of a legal process, it raises issues for people that they might not have thought about, that I think by addressing early on, you can make your life easier and focus more on the creative work. It's
mm-hmm,
in essence an investment in a structure
mm-hmm,
can sort of take away a lot of your worries. If you know that, um, if I want to use a photograph, I need to license it, or vice versa. If someone else wants to use my work, how do I protect it? How do I make sure they're doing what they say they're going to do?
mm-hmm,
And that involves licensing and things like that. But, um, one of the main things is, in any creative project, there's usually more than one person involved. And I find that having a structure that people can agree to, and a lot of things in law, um, like contracts or intellectual property, are structures that are intended to really balance people's interests. And so, in a way, it's sort of designing a relationship that
mm-hmm,
allows you then to say, okay, we've got all the stuff out of the way. We've talked about money. We've talked about how much you can use my work or how you can use it. Now
mm-hmm,
let's get down to work. Now let's be creative and not
mm-hmm.
worry about those things.
Right. So this is one of the questions, since we're kind of close to it, is um, how do you present your ideas and fully give somebody the essence of what you're capable of without, um, like, how do you do that and protect yourself at the same time?
As far as ideas, there are different ways to protect them. An idea that's expressed that let's say you've already created something and you're showing it to somebody else. Let's say you've, created a book or you've created a series of images. Copyright will usually protect that, and so they can see it and they can look at it, enjoy it, talk to you about it, but they're restricted from using it without your permission. But then there's also the issue of ideas, just the idea itself, like, hey, I have an idea for a website, or I have an idea for a piece of software or a book. One of the ways that a lot of people do that is with confidentiality agreements.
Right.
Um, and sometimes it's strange because there's a catch-22 in essence. There's really, different ways, but one of the best ways to protect yourself is to have things sort of already fixed and written down. That
Mm-hmm.
way, you can have copyright protection, or you can have some sort of evidence that you were the first person who came up with a particular idea.
Mm-hmm.
But it's, that said, it can be, ideas themselves are very difficult to protect.
Mm-hmm.
One of the things that, I mean, this is just my own personal
Yeah.
perspective, actually,
Yeah.
is that I tend to give away a lot of my ideas.
Mm-hmm.
And I know that's not something that most people will want to do, or, doesn't really appeal to people. But, I sort of look at it like, to take an idea from idea to, sort of an ongoing venture or business or project, there's a lot of work in between, and
Mm-hmm.
there's a lot of work in coordinating with others, and there's a lot of work in just even producing the thing. And it's one of the places I try to focus on is about like the relationships you have going forward, and the way that you sort of delegate responsibility, and the way that you have things produced.
Mm.
So
Cool.
and different ideas sort of have their own characteristics. I mean, some
Mm-hmm.
things, I mean, obviously everybody knows that you can patent something, um, but there's a sort of a set of requirements that you have to meet before that thing can have the patent protection.
Mm-hmm.
Um, there's also things like trade secrets. So if your business has certain things, even things as basic as customer lists
Mm.
or as business plans, if you take certain steps to protect them and you tell people who are working with you, hey, these customer lists are mine and they're protected, and you understand that and you agree to that, that's a certain kind of protection you can have under the law too.
Hmm.
So it really depends on what the thing is and how that determines how what sort of protection you use, whether it's copyright, trade secrets, trademark, patent. But that's what intellectual property law does in general.
So, do you think if a designer, say, the woman that asked this question,
Mhm,
she's a designer in many ways,
mhm,
and she was presenting an idea to a rather large company, and she was basically expressing her design ideas to them, to see if they would hire her, and it was
right.
her and somebody else. And at that time, she said, I felt really vulnerable, but here I am giving them my ideas, and I felt like, so do I give them that confidentiality, or that, you know, what do, is that,
Or non-disclosure.
or
Well,
non-disclosure? There you go.
yeah, and it can really sometimes be a sort of a business decision, and also reading the sort of relationship and bargaining power. This is also one of the things is that as creatives, we don't always work in a vacuum. There's other factors. A big company can say, well, okay, you've given me an NDA, I'm just not going to sign it. I can hire the
Mm,
next person.
yeah.
Where,
So, what would you say to, say, a freelance, whether it's a designer, a freelance creative?
Mhm.
What would you say, like, the top 3 to 5 tips that you would say, make sure you do this, and this?
Okay. Well, number one, and this is, I'm sure I'm just repeating what everybody else already knows, is get it in writing. So if you're doing work for somebody, get a contract in writing. If you're partnering with someone to make something, get a contract in writing. Now, that doesn't have to be a big, overblown 40-page document, but just a document that says, we're working on this together, and you're paying me this much. It'll be done on this time. I mean, there aren't very many formalities, but you do want to have something in writing. That
Hmm.
said, number two, if you don't have something in writing, don't think that you can't get paid. You can. That's one thing I've heard a lot from people is that if you don't have a contract in writing, you can't get paid. The whole thing with contracts is having one in writing is helpful to basically move things along should there be a dispute.
Hmm.
Uh, the sort of third thing would be to make sure that have a good understanding. And I think for a lot of creatives, the top sort of type of intellectual property we deal with is copyright. So one of the things to know about copyright, well, actually, there's two things I'm going to say together. One thing is, as soon as you make something, you have a copyright in that thing.
Mm.
So as soon as you produce it, you're the owner of the
Mm.
copyright to a thing, unless you have a work for hire agreement or you're working for an employer. If you're working for an employer, they typically own the copyright. Not
Mm.
always, typically, but if you're as a freelancer, as soon as you make something, you're the owner, and then what you're actually selling to a client isn't really your time. You're selling them the right to use your property, which is your copyright.
Got it. Right.
And
Right.
so for me, that was a real revelation when I understood that. I had no clue about that until law school. Maybe everyone else already knows that or knew that, but
Mm.
for me, that really changed my thinking about things because it changes the way you approach work. You're
Well, and this leads into one of the questions
Mhm.
that that I want to read, which is copyright question.
Right.
Is it better to give it over to everyone and retain just the right to self promote and credit? Or I've heard some advocates for usage based pricing, but that doesn't seem to fly with graphic design like it does with photography and illustration.
All right. Well, okay. I'm trying to think how much sort of context I want to give on the issue before answering. But basically, as I said, you're the owner of the work, and so as the owner of the work, it's sort of like being the same thing as an owner of the house, owner of a house. You can say, either I want to lease it to somebody, I want to sell the whole thing, or I'm going to rent out the bedroom. And what you do is going to really depend upon the sort of industry and the expectations that everybody brings to the table. And that's why sort of at the beginning I said it's good to find out what the expectations are, because that might guide you as to how to price and how to and as to what you might offer. So for some industries, people might not care. If you're, let's say you're making a print ad for somebody and they know they're just going to run it once, they might say, fine, we just want a license to run it in a magazine once, and that's it. And whatever happens after that, we don't care. Just don't use it for somebody else. But we don't really care. Others might, for whatever reason, want to retain more rights. And so, one of the discussions you would have, because there is no one answer, it's going to depend upon the parties. One of the discussions you might have is, what kind of usage is the person wanting, and what kind of usage are you willing to give? And really, it's really about discussing the underlying concern.
Mm-hmm.
Clients have the concern that if they don't have full ownership or they don't have, unlimited usage, they might find themselves in a situation where the designer, is no longer available and they can't really work with the materials that they've been provided. So to them, that's a concern. It's something that concerns them and it's worth addressing. On the other hand, as a designer, we all have the concern that we'll produce something for somebody for one purpose and they'll go ahead and use it for everything, which isn't fair. If you sell someone the right to, like I say in my analogy, rent the bedroom, and they start using your other bedroom as an office, you're going to be upset. So it's always good to have discussion about exactly what it is and find out from other people in the industry what it is that that you're selling, because there are certain industries where it is very established what it is people are selling. Photography being a great example.
Right,
if you're a photographer, it's known that you're selling a license to use a photograph in a specific place, and it might be an exclusive license, which is more. It might be hey, it's not exclusive, I don't care if others use it, if it's like stock photography or something. So the standard lawyer answer to everything is it depends, and it does depend. It depends on those things that we just sort of talked about. I think the main goal in this is to go one under and make sure that your assumptions and their assumptions match.
Got it.
So if you say I'm making you a drawing, then they might be thinking, okay, great, I can use that for everything. I can use it in an ad. I can use it for T-shirts. I can use it for this, use it for that. And they may not have any sort of ill will. They may not be trying to pull one over on you. They're just saying, oh, cool, I have this drawing now.
I think each industry kind of has their own understanding of, and like Jen, who asked that question, the question, is that with graphic design, I think that it's established to some degree.
Right.
But I don't think it's established to the degree that most designers would like it to be, or meaning that their clients understand the legalities of what they're creating for them.
Yeah, and that's the thing. I mean, a lot of clients don't understand
Yeah.
what it is they're buying. I mean, the refrain I hear in a lot of things is, well, I paid you money, I own whatever work.
Exactly.
Because I think a lot of clients assume, I'm sort of hiring you as a temporary employee, and anything you produce is mine.
Right.
Which, even though that seems like an overbearing assumption, it's not necessarily an unfair one from their standpoint.
Right.
It's if you and I didn't know any better, we might assume the same thing. And so I think one of the jobs, as a good designer and sort of a good, someone who wants to work well with clients, is to make sure that you have a conversation, whether that's part of your, part of giving them your contract and saying, here exactly is what I'm giving you, or, to make sure your long-term relationship with people is solid. It's always good to have the conversations ahead of time. So there's, you don't want to end up in a dispute where you think it's one thing, they think it's another, and you may lose a client, you may lose referrals, and it's just stressful. I think by understanding those little legal points about copyright and contract, you can do those things where you're like, okay, I'm taking care of my client and making sure that they get it. I think people would rather know up front rather than learn down the line after they've spent money that, what do you mean I can't use these graphics,
right,
on a T-shirt? I thought that's what I paid for.
Right.
And people get mad. I mean, anybody would get angry.
Sure. And truthfully, I think, just a heads up for you, is that what a nice little, little side note is being able to teach your clients how to say that,
Yeah,
because I think that that is really, people get stopped because they don't know, like, they don't know how to approach it, or the language to use, or the confidence of, I know what I'm
right.
talking about, or, you know, there's a lot, all obviously all kinds of factors in that, but
Yeah, I really do think just by understanding, that's what I mean, by understanding the law just a little bit
hmm
and having that perspective, I think can help even with those conversations.
absolutely. And it reminded me of my conversation. The first brew I did was with David Berman,
Hmm.
and he was, after our conversation, I think it was a couple days later, he was on his way to Istanbul, I think it was,
Oh, yeah.
and anyway, he was traveling in to, what was it he called it? It was the Code of Ethics. There it is,
Uh-huh.
for graphic design in Malaysia, and then he was going to Turkey as well. And so, what just came up when you were saying that is, I was thinking about how I think there is kind of like a code of ethics. I mean, doctors and lawyers and all, you know, all kinds of different industries have a certain code of ethics and know what to expect. Where I think,
Right.
where when it comes to creative industry, the creative industry, and different types of commercial creative, that there isn't necessarily a clear code of ethics that the customers can just know or understand. And I think it's somewhat kind of, I mean, I think it's more, but I think it's when the designer, the creative is educated, then they can obviously stand for that more.
Yeah, and it's and I think you sort of raised an interesting point. I mean, even it can be difficult because like you've mentioned, like doctors or lawyers or even like, take a specific kind of creative, an architect. There's usually a group. There's like whether it's the Bar Association or the American Medical Association, they sort of put forth these ethics that if you want to practice in that field, you have to follow them.
Mm-hmm.
Um, I think with design and with writing and with painting and anything else that is, there isn't really that. There's like, you don't need to have a license to design. You don't need to have a license to be a painter or a writer. And I think that, makes a lot of the ethical choices sort of more personal.
Mm.
And so there's a lot of variation. And so I think for clients, they really don't know what to expect from any individual designer. But I think that one of the things I think clients could understand is sort of the language of law as a general sort of set of principles.
Mm-hmm.
But I mean, the thing is, I would also just say, don't be afraid of the law.
Mm-hmm.
It can be intimidating, but I think that the basics are really there to help and understand that, there's different, every party involved in something is going to have different interests. And,
Sure.
one of the things that the law tries to clarify is how do you balance those interests? Because I mean, we're not always going to see eye to eye with people.
Mm-hmm.
And is there a way to sort of identify what the problems are? So, like, one of the things, understanding law can do is really help you to um, sort of narrow down to the real underlying issues.
Mm-hmm. Okay, so there's another question that was really good, and it says she wanted to know. It's a copyright question,
Hmm.
and she's giving a little background and saying, is having a line in the project contract that says something like this sufficient when working with client supplied files like art, photography, etc. And so that it's, the line is stating, client expressly represents that any and all supplied content does not infringe on any rights of others. Client shall save, defend, and hold harmless the company, its vendors, and or assigns from uh, any damages resulting from any final products. So I know it. Yeah.
Yeah. So without commenting on that specifically,
Right.
um, I can say that in general, lines like that are helpful and are important in a contract.
Mm-hmm.
How it's actually drafted. There's a million ways to do it, and there's a million perspectives, and it actually depends on your state. It depends on, where you're located. What the effective language is going to be.
Mm-hmm.
Um, but what with the like really getting beyond the language and getting to what the function of that is, it's a matter of protecting yourself.
Mm,
You might be working with someone who, as a client, doesn't really understand IP necessarily. And so if, let's say they take a picture off the internet and tell you to use it, incorporate it into a design, as a designer, you could be liable. So if that,
mm,
if the owner of that copyrighted photograph finds out that the company used it, they'll get mad at the company, but they'll also get mad at the designer potentially
mm-hmm,
too. And so what a
mm-hmm,
line like that, it sort of insulates and says, you know, not only are you telling me that nothing you've given me infringes, but you're also telling me that, if I get sued, you're going to pay my legal bills.
mm,
It's going to be your responsibility.
mm-hmm.
And so,
Okay, one more question
sure.
is, so the question is around, if you work for, um, so the person who's asking the question, he worked for a company for several years, and he wants to know, interested to know about the use of work designed while employed.
Yeah, so there's an easy answer and there's a hard answer. The easy answer is if you're an employee, like, you've signed an employment contract, you show up at their office at a certain time, you use their equipment, you're getting health benefits, where let's say it's pretty clear that you're an employee. Typically, your employment agreement will have some sort of work for hire clause,
Mm-hmm,
which
mm-hmm.
is valid. Which is totally valid and totally understandable. It's
Sure.
understandable that a business would want to make sure that anything their employees make is owned by them,
Mm-hmm,
because ostensibly that's what you're being hired to do. Um, where it becomes more complicated, the more complicated answer is where somebody might be an independent contractor or might be an employee, and there's a whole legal test that I think has like 7 factors. I'm not going to get into it, but there are a lot of court cases, copyright cases, IP cases, that are decided on whether someone was or was not an employee. Because if you're not an employee, and they have you sign one of those agreements, it might not hold up.
mm,
Because really, like a work for hire agreement, which is what those are called, are generally for employees. And I've seen a lot of clients give independent contract designers a work for hire agreement. Now, whether or not
mm-hmm,
that's effective, again, it depends on whether certain factors are met. Um, things like, do you work at their premises? Do you use their equipment? Do they supervise you? All those things sort of go to determine whether or not you're an employee. And so if you are, yeah, you're basically, they'll probably expect you to sign things over. If you're not,
What?
what you'll,
Oh,
yeah, go ahead.
sorry. Is what about portfolio? I mean, I'm always curious of if you work for a company,
Mhm.
and is it? I guess it's just a matter of what's in your contract. If you're allowed
Yes,
to use that whatever work you did while you were with them in your portfolio.
basically, yeah, and
Is
different
there?
companies
So
have
is
different
there a?
policies.
I'm sorry. I'm sorry. Is there a standard for that, or is it comes down to what the policies are of each company?
Yeah, the first move, I mean, upon being hired, is to read the contract and just make sure. So if having something in your portfolio is an issue for you, and for most people it will be, read the contract, see what the contract says, and if it says something that you're like, well, I really do want to make sure I can use this in my portfolio later.
Mm-hmm.
Again, have maybe have a conversation with whoever's hiring you ahead of
Mm-hmm.
time and be like, hey, can we change this? Is there any way I could do this? Because there are some companies where they really want everything to come from them and not have anyone else representing that they are the person who made it. They want it to all be under sort of like the
Mm-hmm.
cloud of the company. And others are like, yeah, we don't care. We don't care.
Mm-hmm.
Just don't sell it to anyone else. But yeah, the rule on that is read the contract, and then whatever you typically what the contract says is what goes.
Mm.
And I want to point out that that's really strictly for employees, because within the independent contractors, as I sort of said
Right,
before,
right, right,
it gets
right.
more
Yeah,
complicated. There
right.
are gray areas, but with employees, it's fairly cut and dry.
Yeah, because the situation with this particular question is he worked for a company and no longer works for that company and is doing his own thing and had some of their work up on his website, and the company got really upset.
Yeah.
And so
So
I don't know if I'll have to ask him about his contract, but I'm not
yeah,
sure.
Yeah, it would depend on the contract. I mean, if it also depends on if there is sort of a work for hire agreement, because what the work for hire agreement does, like I said, very early on in this conversation, is as the creator, as the designer, as the person making something, you're the owner of the copyright.
Mm,
You
right.
can you can decide what rights you want to dole out to people and how you dole them out. Now,
Hmm.
if you under work for hire, they're the owner of the copyright. As soon as you make something, as soon as you do something in Photoshop or do something in Illustrator, that's their work. It's as if the company is doing it. So the default is then you'd have to ask them for permission to get the right to show it in your portfolio.
Hmm.
So it sort of reverses the roles in a certain way. So yeah, that's it depends on you're an employee and what the contract says.
Hmm.
Um, but yeah, and a lot of companies are very protective, and agencies are very protective of how the work is displayed elsewhere.
Hmm. No, I was just going to say, so what can people expect from you in the next little bit? What do they need to keep an eye out from you?
Well, yeah, the main thing we're sort of moving forward with is doing more workshops, and looking at doing ones that are more targeted towards very specific issues. We've started by doing ones on contracts, and we're doing one on sort of business entities. But that's while it's interesting to people, I'm seeing that people have very specific questions. In the
Hmm.
course of doing the workshops, I see that people, have certain sort of problems they want to solve.
Mm.
And so, the thing I'm sort of pivoting on is to find what are those problems and how can I sort of make a presentation or a workshop that would address just those problems. I mean,
Hmm.
if someone still wants to know about everything there is to know about contracts or at least have an overview, that's available. It will be available. But also if there's something like how do I use my contract to get paid? That's obviously very important.
Hmm.
As much as we like our work, we do want to get paid, and it's hard to work if you can't pay the electricity bill, etc. So,
Right, right.
it's very practical. And down the line, one of the other things is to sort of start producing printed works or ebooks that address the same issues. And so
Hmm.
I really want people to have a choice of how to receive the information. Some people
Hmm.
like the sort of physical, they're there, and we can have a discussion, we can have questions answered. Others just say, I just want the information.
Yeah,
I just want to know. I want information from a reliable source. So just tell me. If I have questions, I'll come to you and ask you later. So that's what I'm trying to do, is just sort of provide different ways to help people get that information.
hmm, I love it. So if somebody wants to work with you one on one, that's possible as well.
Absolutely. Yeah, the I have my law practice is called Counsel for Creators, counselforcreators.com,
Hmm.
and I work pretty much exclusively with people who are creative professionals and creative businesses. So a lot
Hmm.
of the people I work with, either they're freelancers or they are creating a new product and they just want help getting things set up, or they might even have an older sort of product or business that they've been running for a long time and now they want to sort of figure out where they are legally. And that's
Mm.
one of the ways that I start with a lot of people is we just sort of in general talk about their about their business. What are
Sure.
you doing? What are you trying to do? And then I sort of see what I can do to offer them advice. Understanding that obviously you can there are many places you can put your time and attention and money.
Hmm.
And so I just sort of give everyone the choice. I say hey, here are some things I would suggest, and you can do them, you can not do them, you can do them later, whatever. But just I just like to give people information. And so like working one on one, it gives me a chance to give more specific information,
Hmm.
because with something like semi-aware, I have to be very general.
Hmm.
There's really there are ethical rules about me answering specific questions. So
Mm.
that's why even today, if you're asking me questions, I'm somewhat evasive
Right, but
uh,
that's okay.
on the
Yeah.
points. I'm not an evasive person. It's just that I would hate to tell someone something about their specific thing and
Hmm.
have that be incorrect, or me not know some very important fact
Right.
that changes everything, and then have them go and do something and
Sure.
cause a problem. That would be the worst. One of the things I often say to people is that a contract is a collaborative tool. It's not an adversarial tool.
Mm.
And there's my number 4.
That's a
That's
good
my number
one.
four.
I like it. Ooh,
It
that
is.
is
It
good.
really is. I believe that. I believe that, you know, when we hear the word contract, it sounds bad. Sometimes it sounds like, someone's going to try to pull something over on someone else, or someone's going to try to get someone to do something they don't want to do, or there's going to be a bunch of fine print that you don't understand.
Hmm.
And while some people do that, I think for most people who have a positive outlook and want to get something done with someone, whether it's a client or a partner or a collaborator, um, you want people to walk away happy, from the
Hmm.
experience. And so, by having a contract that spells out all of the issues and spells out all of the assumptions, and you can eat it, just a good reference, like
Hmm.
when months down the line, you know memories fade. 6 months later you might not remember, oh, we made this product together, what's the split of royalties, or how are we going to split the profits. If you have it written down at the very beginning, you're like, oh yeah, okay, here's how it was. Or
Yeah.
who is going to supply certain imagery, and what,
Hmm.
even things like, like working with a client, um, what content will the client supply.
Hmm.
Just saying that all ahead of time rather than in the process of designing, it can really free things up.
Hmm.
And it's good to have it written down. And so it can be a real collaborative process. Like the process of negotiation can be collaborative rather than competitive. Like it doesn't necessarily mean, you know, you're trying to get more and they're trying to get more, and so you have to fight.
Right.
Some people might be like that, but it doesn't have to be. That's not the necessary default.
Right. Right. That's great. That's a good number four.
Yeah. So I knew it would come up. I just didn't know when. Yeah.
So, if somebody would like to connect with you, can you tell us a few ways to do that?
Yeah, the easiest way would be to go to my website, which is Counsel for Creators. So it's counsel, COUNSEL, like lawyer, counselforcreators.com. My email address is there. Um, you can also go to semiaware.org, semi-aware.org. I'm there too. I'm also on Twitter as Hexodus, Hexodus.
So, thank you for joining us today for Creative Jam with Jonathan Tobin, and we will have all of his information so you can contact him at the end of this session. Thank you, Jonathan, so much.
Thank you very much.